This video delves into the evolution of international law over 30 years, focusing on a legal tool called the blocking order. We'll explore why this law sat unused for 5 years and its sudden activation. The story begins on May 2, 2026, when a lengthy document, Notice Number 21 of 2026, quietly appeared on the MOFCOM website in Beijing. Despite its low-key release, this notice immediately sent shockwaves through the international legal community. The core of the matter is China's blocking rules, specifically MOFCOM, Order Number 1 of 2021, the rules on counteracting unjustified extraterritorial application. This law took effect immediately on January 9, 2021, showing the urgency. For 5 years, even amidst major international disputes, this law was never used. The crucial question is, why was the blocking order activated now, right on the eve of a major diplomatic visit? We will examine the scale of this event in international legal history and, most importantly, who this activation actually affects. This video will unpack each layer. This pattern of legal collision is not unique to US-China relations. Our 30-year timeline begins with the EU's pioneering efforts in 1996, the resolution in 1998, and its reactivation in 2018 and 2021, leading to China's first actual use in 2026. The real cost of these actions often falls outside of government. Chapter 1 focuses on 1996, the EU's story and the birth of the blocking statute. We'll discover how this legal weapon was created and why it remained dormant for so long. On March 12, 1996, President Clinton signed the Helms-Burton Act. Months later, the D'Amato Act followed with Iran and Libya sanctions. These two laws introduced secondary sanctions into international practice. Primary sanctions bar a country's citizens from doing business with a specific nation, falling within sovereign jurisdiction. Secondary sanctions, however, bar anyone in the world from doing business with that nation, a new concept in international law. Helms-Burton's Title III even allowed lawsuits in Miami courts against foreign companies trafficking in confiscated Cuban property. The world reacted swiftly. Canada and Mexico asserted their sovereignty, while Europe declared Helms-Burton a violation of GATT Articles 11 and 13. In response, on November 22, 1996, the EU passed Council Regulation 2271/96, the world's first formal blocking statute. Europe's pushback was twofold. Track 1, the blocking statute, which disallowed compliance with US laws, permitted countersuits, and made US judgments unenforceable. Track 2, a WTO challenge, asserted that the US law violated GATT. This represented post-war Europe's most aggressive legal pushback against Washington. The conflict was resolved through diplomacy, not litigation. On May 18, 1998, the EU and US signed a Memorandum of Understanding in London. The US committed to suspending Title III every 6 months, while the EU committed to withdrawing the WTO case and not enforcing the blocking statute. The result was a 22-year freeze. The statute was passed in 1996, resolved by the MOU in 1998, and then routinely suspended by successive US administrations. The international legal consensus held that the 1996 statute remained dormant as disagreements were settled by other means. The first historical lesson is that blocking statutes are most effective when their existence creates deterrence and forces diplomatic resolution. This makes them similar to nuclear weapons, most effective when they aren't fired. Remember this lesson. It will be relevant later. Chapter 2 takes us to 2018. The EU finally activated the statute, only to find that it didn't work as intended. This is the story of when the legal weapon was finally used. On May 8, 2018, the US withdrew from the Iran nuclear deal, reinstating full sanctions, including secondary sanctions. In response, on August 7, 2018, the EU updated its blocking statute annex, adding the new US-Iran sanctions to the prohibited compliance list. In 2018, European companies universally chose to leave Iran, despite the EU statute prohibiting withdrawal. For companies like Total, Allianz, and Maersk, the choice was simple. A few million in EU fines versus losing access to the US market was an easy calculation. The conflict came to a head in the Bank Melli case. Bank Melli Iran, the plaintiff and a telecom client in Germany, sued Telekom Deutschland after it unilaterally terminated service shortly after Bank Melli was added to the US SDN list. On December 21, 2021, the first CJEU ruling favored Bank Melli. The court held that Article 5 directly binds EU companies, no US court order is needed, and Telekom's unilateral termination violated the statute. This was Europe's strongest legal pushback against US secondary sanctions. However, after the ruling, Telekom never restored service. The CJEU ruling contained a loophole, stating that the court may permit termination if an EU operator can demonstrate disproportionate economic damage. Telekom's US business provided sufficient basis to argue this disproportion. Europe attempted another move with INSTEX, an instrument designed to bypass the dollar and SWIFT, allowing European companies to trade with Iran without US visibility. But after 4 years, INSTEX completed only one transaction and was officially shut down in 2023. The second historical lesson, confirmed by a Mayer Brown analysis, is that EU companies prefer to comply with US law, even if it means incurring million-dollar fines in Europe. Legal collisions don't necessarily change business choices when faced with the size difference between the US and EU markets. Chapter 3 brings us to 2026 and explores why China's response is fundamentally different. This round may produce different results compared to the EU's past efforts. China copied the EU's framework in 2021, including a compliance ban, civil action mechanism, and administrative penalties. Yet, despite multiple US sanctions rounds targeting Chinese entities since 2021, China waited 5 years before activating its blocking rules. The reason China waited so long lies in the trigger. The EU was only indirectly hit by sanctions on allies like Iran and Cuba. China, however, was directly sanctioned. The blocking statute is designed for secondary sanctions, and China was waiting for a case where its firms were hit for trading with a third country. That trigger came on April 24, 2026, when OFAC added 5 Chinese refineries to the SDN list. The legal basis was Executive Order 13,902, which sanctions any global entity engaging in Iranian oil trade. This was exactly the third country scenario China's blocking statute was designed for. On May 2, 2026, MOFCOM issued Notice Number 21 activating its blocking rules. This includes civil action allowing the 5 sanctioned firms to sue counterparties, a compliance ban, and administrative penalties. The tool was activated conveniently on the eve of a major diplomatic visit, serving as a powerful signal. This time is different from 1996 and 2018 for 4 key reasons. First, the form of impact. China is directly named. Second, company calculus. The Chinese refiners have no US business to lose. Third, clearer Chinese penalties. Fourth, no US-China diplomatic off-ramp is currently available. This means the blocking statute may actually be enforced. Chapter 4 examines the real losers in this legal conflict, the multinationals caught between 2 powerful legal systems. The true cost of this geopolitical friction is borne by those who must navigate conflicting demands. Multinationals face a direct legal collision. Complying with the US violates the Chinese statute, exposing them to lawsuits and MOFCOM fines. Complying with China violates US sanctions, risking OFAC action and cutting off US market access. Anyone with both US and China business must choose a side. A wide range of multinationals are caught in this squeeze. International banks like HSBC and Citi, global shippers like Maersk, insurance firms like Allianz, oil traders, and auditing firms. Each conducts daily business with the named Chinese refiners and now faces an impossible decision. Multinationals have 3 options. Option A, comply with the US, which means China can sue and seek damages. Option B, comply with China, which means OFAC can sanction the multinational. Option C, seek both waivers, though OFAC is unlikely to grant a waiver and China has no precedent. The urgency is evident. In the past 24 hours, major international law firms, including Gibson Dunn and Clifford Chance, issued urgent client memos. Their message: there is no precedent, and firms operating in both China and the US need to review their contracts now. MOFCOM's official statement carefully framed the action. It opposes unilateral sanctions without UN authorization or grounding in international law. This specific wording is key, mirroring the legal logic of the EU's 1996 WTO challenge. As of today, Washington has provided no official comment. The OFAC website, State Department, and White House are all silent. This is the standard playbook, where silence means no recognition of opposing legal claims, and enforcement continues normally. The most likely scenario involves gradual structural separation. Multinationals will begin separating their China and US businesses into fully separate legal entities, with 2 banking stacks and 2 compliance programs. This isn't one company's problem. It's the next 5 to 10 years for every multinational. Chapter 5 summarizes what this storyline really means, examining the 30 years of legal evolution that led to this moment. The evolution of the international economic order can be divided into 3 stages. 1996, US alone, where only the US had secondary sanctions power. 2018, EU tries, where Europe attempted to build an alternative system. And 2026, multipolar, where each major economy now has its own countermeasure tool. May 2nd signifies 3 major implications. First, legal globalization is fragmenting, leading to more cases of legal in country A, illegal in country B. Second, deterrence is becoming enforcement. Third, compliance complexity is accelerating, a structural cost ultimately passed to global consumers. May 2nd is not just another US-China escalation. It is its own specific node in 30 years of legal evolution. The resulting compliance cost ends up in the price of everything you buy. Join us for the next episode, EP.06, where we explore how US secondary sanctions evolved, from Helms-Burton in 1996 to today's multi-front toolkit. Please like and subscribe if this video was useful. See you next time.